Rewinding Kaya FM on FM Rewind. Kaya FM, home of the Afropolitan.
Good evening, Kaya. Good evening, Kaya. Good evening, Kaya. Welcome to the Law Report. Visit Mlila standing in for my big brother, Michael Motsonengbill. I hope you had a very wonderful day, and I hope the week has been going on very well for you. And the remaining 2 days in the week, I equally believe that will be good days. Tomorrow is Valentine's Day. I hope everyone is ready for the day. I'm still looking for a white shirt, a red shirt, and flowers, and I hope the chocolates are ready. And may I wish everyone a happy Valentine's Day tomorrow, and I hope all of you spread some love. On the show today, we are discussing the Copyright Amendment Bill. You would know that there are attempts to amend the Copyright Act, and you browse through the internet and general comments around the attempt to amend this act. You see that there's an avalanche of disagreement. There's an avalanche of hardcore expression of dissatisfaction with the manner in which things have happened as far as the copyright issues are concerned. And this topic is important, I suppose, in a sense, for people who are in the music industry, who are authors, or people who think that they have ideas that are worth protection, and having those ideas protected, they would want to derive some economic benefit out of it. So during the show today, we hope to understand what copyright is, and we also hope to understand what the amendment seeks to achieve, and for that matter to try and understand what it is that in this amendment that has caused so much contention. So in studio, I'm joined by Bra Wiseman, and he will be helping us to understand what these issues are. He lives and breathes copyright law, and also in studio I'm also joined by Hugh. He's a partner at a law firm that almost on a day-to-day basis specializes in copyright law. I was talking to him earlier on about this, and he said, no, this is what pays his bills, basically. So I hope to benefit, and also, Mkaya, that you benefit from the wisdom of the two gentlemen. And on the phone from Cape Town, we're going to be having Prof. Sadula. I hope that we will be able to get him on the line. Gentlemen, welcome to the show. I know just before the show, you were saying almost in an animated way that you have a lot of things that you want to say, and I was saying I hope that by the time we finish the show, copyright is an extremely complex area of law, and it's not an area of law that everyone listens to, or rather follows on a day-to-day basis. But when people have ideas, you always hear that, can I copyright this? Can I copyright that? So in this show, I hope that we'll be able to explain to Mkaya whether or not what exactly this means around copyright. So maybe as a starting point, Bra Wiseman, can you explain generally what copywriting is?
Well, thank you for that introduction, and greetings to Wonkum Kaya out there. So I think the general principle of it, I suppose, is that copyright is more or less a system that seeks to encourage innovation and creativity by granting people who create something original a limited monopoly on that thing once they reduce it to a tangible format in some way. So basically, you think of an idea, you reduce that idea into into a format that you can access. I suppose an easy illustration is something you can access with a few of your five senses. So if you can see it, if you can touch it, if you can read it, those are the types of things that have now been reduced into a tangible enough format.
But how do you reduce an idea into something tangible? Because it's something that exists in the mind.
Okay.
So I say I have an idea of how certain events must be conducted, and I want to go and suggest it to an events company. Mm-hmm. It's an idea that I have in my mind. How do you demonstrate its tangibility, as it were?
So you reduce it to writing. It's the easiest way. So I'll use an example with music, which is my comfortable forte. Is people will come up with an idea and a melody in their heads.
Yes.
They then write that down in back in the days in historical senses. They would reduce that down into a musical notation before it was even recorded.
Yes.
So that musical notation has copyright in it.
Okay.
It is copyright protected, and once you then take that musical notation, you get into a studio and you record it. A second copyright exists in that particular version, because you've now taken what you have written and you've performed it in an artistic way, in an original way, and you've recorded it. And so a second copyright would exist in the recording versus the original musical work.
Okay. Mkaya, if you want to join in the discussion, give us a call on 086 00959, 086 00959, or send us a message on WhatsApp 063 688 0959, 063 688 0959. Would really appreciate your participation in this conversation. It's an extremely important conversation, so that who knows, you probably are holding an idea that might actually make you very rich at some point. So you, if from what he is saying, is it sufficient that this idea has been reduced to some form of writing? In other words, does the person need to do more for you to then establish that there's a copyright that has been established there?
No, not in South Africa. Thanks for having me on the show, and it's really great to be. And hi to listeners. Copyright subsists automatically, so there's no registration of copyright. Okay. The way it works is that the Act sets out certain works that are capable of copyright protection, as Wiseman pointed out. So one of the works would be a literary work. When you write the words down, so a story, the words of a story. As soon as you write that story down, copyright would subsist in what one has written down, not the idea behind the story, but what one has actually written down. So the idea of a British spy who goes behind the Iron Curtain and spies on the Russians and gets up to all sorts of no good and mischief, that idea is not protectable. There are many stories around that. There's James Bond, there's Smiley's People, etc. What is protected are the words around that story.
So in other words, the arrangement of the words.
The arrangement of the words. Okay. And it's exactly the same with music. A musical work is also, once that musical work has been written down, reduced to what we call, as we say, the material form, protection would automatically exist. Ideas is not a work that's capable of protection. The Copyright Act doesn't protect ideas. What it does protect is the expression of that idea, the way that idea is actually created and written down and given to the public. So, for example, the sound recording of the song, the record, that is a work that's capable of copyright protection once that record is created. Before that record is created, there's no copyright protection in the idea of creating a record by a particular artist.
So say, for instance, I have a business idea, and I reduce it to writing in the form of a business plan. And let's assume that that business idea is innovative in nature. Am I understanding you correctly to be saying it is not the idea of the business that is protected? It is actually what it is that I have written. So much so that someone can go and implement the idea without the written text that I would have used.
Absolutely. Correct. So that is 100% correct. And the ideas are not protectable. And I'll give you a tangible example. A computer program. Yeah. So I've got a particular computer program that I use to in my business to sell widgets, and I've got a fantastic web page that runs my business, and it's just a fantastic computer program. What is protected is not the manner, not the idea around that computer program. It's the computer program itself. It's the source code and the object code that is protectable, not the idea around it. So I can see a particular, I can go into the World Wide Web, see a particular web page that I like, or a particular program that works well for me, a particular app that works well, and I can copy the idea behind the app. I can reproduce the idea behind the app. What I can't do is copy the works on that particular page. So if there's a song or there's a drawing or particular words or a photograph, I can't use that on my web page, but the idea behind it I can use.
So I've often had scenarios where someone says, I have a business plan that I want to go and pitch to company A or B, but I'm scared that if I go and pitch that idea to them, they're going to steal it. I mean, that in some instances, that's the exact words that those are which I use. So are you saying that that fear
is well-founded?
Yes.
That fear is very well-founded.
And in other words, there's nothing you can do.
There's nothing you could, and it's theft. I agree with you 100%. It's theft. It's theft of the idea, but that idea is not protectable. One of the first matters that I dealt with when I joined Spur & Fisher was three women who had come up with an idea for for a reality program that they'd pitched to one of the broadcasters. And the broadcasters told him that they don't particularly like the idea. It's not really going to work. May work in a couple of years' time, but that's not really for them. A year or so later, they were watching television, and lo and behold, their pitch was now being broadcast over the particular channel. They were obviously upset, came to consult with us, and there was unfortunately very little that we could do. Well, there was nothing that we could do because the idea is not protectable. The only way that you can protect an idea is by way of some form of confidentiality agreement. And again, that protection is not absolute. It's imperfect protection. Yeah. And that protection only lasts as long as the information that's being protected remains confidential. As soon as that information enters into the public domain, it's no longer confidential. And we've seen that recently, as I understand it, with the Makati judgment, where apparently there is some reason that the idea is not confidential. It was in the public domain before, and if that is the case, then the confidentiality regime behind the idea could not be protected.
Okay, so I think we've canvassed this, and at some point I want to come back to you, Wiseman, and maybe start thinking about what he has said, because what he's essentially submitting is that it is theft, but tough luck. So, and I want you to start thinking around, because I can assure you there are many people who have ideas that they are scared of taking to various forums because they think that their ideas can be stolen. Notwithstanding what he has said, within that realm of darkness, as it were, is what can be done to minimize. I'll come back to you in this. What can be done, and I want you to start exercising your mind along that way to say, what does a person who's sitting in Alexander, who has a brilliant idea that they want to take to one of these big corporate companies, but is scared that something, to minimize the damage, as it were, what is it that they should do? Mkaya, give us a call on 086 00 959. Would be very happy to have an engagement with you. We're talking about the law of copyright, and later on we're going to debate and discuss the amendments that are sought to be introduced to the existing act. Let's go pay the rent.
Know your rights, know the law. The Law Report with Michael Motsoeneng-Bill.
Welcome back to the Law Report, Mkaya, with me, Ngovizi Tamlila. I'm standing in for my big brother, Michael Motsoeneng-Bill. We're speaking about copyright law and the amendments that seek to be introduced on copyright. In the first part of the discussion, we've established what constitutes copyright. We've established what it is that can be subject to protection under copyright law. And quite interestingly, we've also now established what it is that cannot be protected under copyright law. And I think some of the things I'm hearing make me shiver. Let's go to Cape Town. And Prof, how are things in Cape Town?
I'm sitting in the darkness, literally, of course, due to load shedding has just kicked in.
Yes.
Thanks to the ANC-led government, who's also the band of bandits that are bringing us the new copyright amendment bill.
I know where you're going with that, Prof. I'm told you need a passport to come to Cape Town now.
We will gladly accept visitors. It's not as foreign as parties will let you believe.
Yes. Prof, you've been listening in the discussions, and we have established, as I indicated earlier, that what it is that constitutes copyright law and what it is that can and cannot be protected. Now, there's a lot of contention around the attempt to amend the existing Copyright Act, and it's clearly an act that was enacted a very long time ago. So, as far as the amendments to the act are concerned, this bill, what gripe do you have?
If I can, I was cut off the call a bit, but I think I got the gist of what Wiseman said and you. But I think, and as you ended off your previous segment, you were speaking about there's somebody in the township that has a brilliant idea, and we should think about how that person can be helped.
Yes.
Now, firstly, I think we need to take a step back, because there's an area of law called intellectual property law, and that is an umbrella term for various types of protection. You have, within that umbrella, you have things like copyright, which we're speaking about tonight, and I'll elaborate on that a bit further. We have something like patent law. We have something like design law, and something like trademarks. So typically, if it's something like an idea and you really want to protect an idea, the only ideas that the law protects are relating to technical things like inventions or chemical formulas, absolutely new stuff that have never seen the light of day before. There you can protect the actual idea through a patent, for example. If it is something that's, for example, a new funky design for a chair, or the aesthetic looks of an article, you can file design protection for that. And then copyright protects certain types of work. And as Wiseman and you have said, copyright doesn't protect ideas. It protects a particular expression of an idea. And I'll illustrate this to your listeners in a way that should be perfectly understandable. So there is nothing protecting or stopping you or your listeners from writing a book about a little boy who goes to magic school and has two friends. Now, I'm sure you have heard of a very popular novel, a series of novels with that idea, that concept. Copyright law doesn't give that concept or idea that as a monopoly to anybody. What copyright protects is a particular expression of that idea. So there are lots of books about vampires, and they all could attract copyright protection, provided it is an original work. In other words, it's not copied and the result of the labor of the particular author. So I think it's important to be clear about what copyright protects. It protects a particular expression of an idea, because there's a lot of myths surrounding copyright, that copyright stifles creativity and innovation and stuff like that, which is pure humbug.
So, Prof, what does that phrase, protecting a particular expression of idea, mean? So does it mean that if you write a statement with a particular sequence of words and express an idea, and I express the same idea using different words, I'm entitled to do that?
Infringement.
And
so, for example, and copyright doesn't protect facts, It doesn't protect commonplace information. So, for example, you can have 40 people writing a textbook on economics. And they could all be protected by copyright. So once I've understood the principles of economics or accountancy or geography or physics or whatever you want to write about, if I've understood the concepts, I am perfectly at liberty to write my own textbook.
So Prof,
which copyright will protect.
So, Prof, if I may probe that, maybe for the benefit of some of our listeners who are perhaps in varsity now, and I remember this being drilled in us when we were in university, that you should not plagiarize. So which explains my earlier question. Mm-hmm. I would have expressed the same idea expressed by Professor Batchel in Principles of Criminal Law, mm-hmm. Using a different sequence of words to the way he would have done it. He would have explained dolus eventualis in a particular way. And I expressed the same idea, and I'm told you should not plagiarize. Am I misunderstanding you, or is there a relationship, for that matter, between copyright and plagiarism?
So let me illustrate again. So plagiarism is intellectual dishonesty, right? So where you're passing off somebody else's ideas as your own. You might not have taken their expression, but you've clearly taken their ideas and passing it off as your own. So, for example,
so that's a realm different from copyright.
Shakespeare is long out of copyright. It's not protected by copyright anymore.
Okay.
But if I were a school student and a teacher asks me to write a little poem, and I submit a long sort of lost poem of Shakespeare that it's not very popular, so nobody really knows about it, and I submit that as my homework. Now, clearly there's no copyright infringement because the copyright is for a limited period, it's expired, but that is clearly plagiarism. It's intellectual dishonesty.
Okay, Prof. Let's up the discussion a little bit. You had all kinds of adjectives about describing this bill. What is it that you have a problem with about this adjective?
Okay, so my main problem is that copyright, like I said to you, whether it's patents or trademarks or copyright, it's a form of property. So we must understand that intellectual property is property.
Okay.
It might not be tangible, but it is property. And, I don't want to get too political, but I think we are being sold some sort of pup. People are going on about land. And, of course, land is an incredibly important issue and a very emotive issue in South Africa. But you know what the most valuable piece of real estate is today for young people? And that is the piece of real estate between their ears.
Okay.
We should be encouraging people to create stuff which the law protects as property. So somebody could sit in a shack somewhere and write a fantastic novel and be the next J.K. Rowling, who's now apparently richer than the Queen of England. And copyright will protect that. Copyright is property. It's the cheapest form of property you can get because there's no formality involved. You don't need to go to any government department. There's no bureaucracy. Copyright subsists automatically in works that you create within the ambit of the Act, like novels, like textbooks, like music. These things, you don't need lots of money to create property which the law recognizes. And the problem with the bill,
yes.
You want to know what my number one problem is?
Yes.
It dilutes the ownership rights.
Okay. Wiseman, you seem to agree that I think the expression used is that it dilutes ownership rights. I mean, what does that even mean? Let's break it down in a manner that is comprehensible. When we say it dilutes ownership, and he has defined. So I think what he is saying is that an idea that is reduced, a particular expression, if I may use the words that you are using, constitutes property. And this being property, it can be turned into money. And therefore it needs to be protected. Now, he then says the criticism is that it dilutes.
Yeah.
In what way?
So one of the main problems with the bill is it almost used rhetoric that says or assumes that the departure point is to increase protection for the people who create copyright, particularly musicians and creators of recorded material. But then when it gets down to it, it actually creates a lot more holes in the way in which you can exercise that exclusive right. So there's certain ways in which you need protection in the digital environment, and this bill fails to do so.
In what way?
For instance, when you've created a song, let's say you record a song today, you upload it onto a platform like YouTube.
Yes.
Right? That particular song will then travel the world. YouTube has about 1.9 billion people logged on every day. They have more than 1.9 billion users. It's just 1.9 billion logged on users every day who then consume that content. What copyright protection is supposed to do in the digital environment is give you more protection on how people should interact with your content on platforms such as YouTube.
Yeah.
But what this bill does, it gives way more exceptions on platforms like YouTube and on platforms that are on the internet around how people can use your work without your say-so.
So the existing act, what does it say?
So basically the existing act is too old to even contemplate what a digital environment is.
Okay. So, then the new act is insufficient as far as you're concerned. Yeah. What should it have said?
So there should have been a lot more emphasis on saying people who create material need more protection from. So there's things like in the European settings, things like Article 13 that looks at how user-generated content platforms like YouTube need to put more protection to ensure that or they compensate fairly the people whose music and copyright material is being consumed on those platforms. It should look at things like how the exceptions that the bill seeks to introduce are balanced, so that the people who actually need revenue from creating.
So Wiseman, so you are sitting in Parliament. And you Prof, like I said, has used a lot of adjectives about this. You are sitting in Parliament and they say to you, what is it that this bill should say? Mm-hmm. Specifically, what is it that you want this bill to say that gives you the comfort that it achieves that which the old act does not achieve, because at the time at which it was drafted, it could never have contemplated the scenario that we have today. So I suppose I can put the same question to you to say, you are sitting in the parliamentary committee.
I have over 60-70 pages of exactly what the bill should say. So
no, yeah. So let's canvass some of them in yeah.
So there's so for instance,
so our concern is this person that is, let's say, a musician who has created this melody and they want to put it on YouTube. What would you want that protects them?
So one, YouTube has an ability at the moment to dictate the relationship between people who own copyright and how those people earn on the platform.
Okay.
They have certain parameters they can set when you can earn and how you could earn. Automatically, the exclusivity of your work on the platform has been diluted.
Okay.
So, because the departure point, if it's my work, whenever you use it, you either need my permission or you need to be paying me a fair value for whatever I've put on the platform.
And that is directed to YouTube in this
user-generated content platforms, but YouTube is the biggest one.
Okay.
So YouTube specifically, for instance, will tell you that you need 10,000 subscribers and a certain number of watch time over a particular period before you can monetize on the platform.
Okay.
Which means if you
Okay.
always fall below that threshold, you can never earn on the platform.
Okay.
That is a fundamental departure. What the bill should be able to do is say users of content on that platform, such as YouTube, are forced to interact with your content in the same way an SABC is forced to interact with your content.
I see.
Because
so every time you play
Yeah.
someone, there's an automatic system of royalties and so forth.
Yeah.
Okay. So in other words, you want every production of every sequencing of an idea.
So it's not even every, because there's certain acceptable allowances
Okay.
that have long existed in copyright as exceptions,
Okay.
and those aren't the problem. It's how fundamentally the drafters, particularly the Department of Trade and Industry, when they were drafting this, forgot to prioritize protection of the creator when they were drafting. Some of the terminology, some of the concepts they were bringing in were a fundamental departure from the idea of copyright in itself, which is let's give limited protection to the people who create creative content.
I'm with you. No, I follow. I am this from Johannesburg.
Hi.
How are you?
I'm well, thanks. How are you, sir?
Good. Welcome to the show.
Thank you. Thank you for this opportunity for us to call in. I have a question regarding patent as well as trademark.
Yes.
In a situation where you might, you have this amazing invention, right? And at the time, you don't have the resource to pay a patent attorney to get a trademark and registered and all that jazz for you, right? However, you've had a paper trail between you and the necessary parties that you were involved with to get this invention, almost like in a digital space. So, you know, the people that you're going to pitch it to have an idea of what it is that you want to invent, right? Because it's not trademarked or patent, and you want to pitch this idea to potential investors or corporates, and they go behind your back and steal that which you have presented to them. Are you able, from a legal perspective, are you able to assist someone in my situation who has been, who's had the idea stolen?
Yeah. I kind of threw cast and I knew this was gonna. Yeah.
I'll try and answer it. I've been involved in a couple of matters around ideas, and the only possible way that you can protect the idea is when you approach your funders or whoever you're going to be putting the pitch to, you enter into some form of confidentiality regime, where as long as your idea is novel, is confidential, your ideas are confidential, the person that you pitch it to or the entity that you pitch it to is not allowed to talk to anyone else about it, to use the idea, and if they do, you're then entitled to approach the court to prevent them from doing so and possibly get damages. Damages, however, are often very difficult to prove. So that really is the only possible way of protecting an idea that hasn't been protected through one of the means of the intellectual property regime, such as by way of a patent or alternatively a design. So that's really the only possible way that you can protect it. And again, another difficulty that you're going to be faced with is that at some stage you really have to pitch that idea. Otherwise, it remains an idea, and whilst you don't pitch it, you get nothing of nothing. At some stage, you do have to take the risk. You have to try and get that idea monetized, and you have to take the risk. And the only possible protection that you can get is, as I mentioned, some form of confidentiality agreement with the people you're pitching to. But it's a very difficult situation that you do find yourself in those circumstances.
So I understand. It's worrying me. So people that have ideas, the best shot they have is to have the idea patented.
Yeah, a patent is only, you can only register a patent in very specific circumstances. So so for example, a business idea a patent cannot be registered over a business idea. There's a debate around the registration of patents for computer programs. Generally the accepted principle is that you can, but again, that's also a little debatable and really, the concept has to be pretty novel in order to get the patent registered. So patents don't protect general ideas. It's specific ideas relate. For example, as I said, business ideas are not protectable.
So Mlilo, I think one thing that we should highlight is the law makes specific provision for certain types of expressions of ideas that can be protected. So from a copyright perspective, there's 8 different things. It should fall in one of those categories. Yeah. From a patent perspective, it should be an invention. Okay. So your idea should be creating or inventing something new. And a design perspective, it should be a novel design that warrants protection. And then from a trademark perspective, it should be a distinctive mark that separates you from everybody else within that space. So it's very specific and technical times in which it can be protected. So for instance, if I want to get into farming and I have a business plan as to how I'm going to get into farming, that is not a copyright protectable expression. Yeah. I've written a business plan. It's just a business plan. That's exactly what it is.
And there's no patent that could be registered over it, no design or anything.
So what it is just a business plan. So we need to separate protectable expressions of those ideas from ideas that are generic in nature.
Wow. Okay. Thank you. It's extremely informative. I think I'm quite intrigued by the idea that you have a business idea and you want to go and pitch it, you're scared about this and that. What we are really getting is that what you really need is a confidentiality agreement. That confidentiality agreement's ability to protect you is limited. It's
imperfect.
Yes, yes. I think the perfect word is imperfect. Okay, let's go ahead and pay the rent.
Know your rights, know the law. The Law Report with Michael Bill.
Welcome to the Law Report, Mkhaya. We are talking copyright law with me, Ngovizi Tamlila. I'm standing in for my big brother, Michael Bill. I'm joined in studio by Brayu and Wiseman and Professor and Prof Sadula in Cape Town. Prof, if I may pick up from you, I think we have traversed some distance now, and where I wanted to get to is your quite clearly expressed dislike of the amendment. What is your criticism of the bill insofar as the use of, as far as academic work is concerned? A professor at the University of Cape Town Law School, and I see you're in Stellenbosch. We're still to settle the debate which one is a better law school, UCT and Stellenbosch. So
Rhodes is we're done.
So a professor at a particular university writes an academic textbook. What is it that is in this amendment that doesn't satisfy you?
And I think that's the gist of the question. How do we protect innovative ideas in the township, etc.?
Yes.
Now, here, for example, it's rather technical, but I just want to illustrate why this copyright amendment bill is bad drafting on a number of levels. There are a few provisions in the copyright amendment bill which stems from the apartheid era, which I think acts against the interests of township innovators or innovators generally in South Africa. So, for example, there's a provision called 15.3 capital A, which was a bit of sanctions-busting legislation during the apartheid era. And it's so broad that you either file a registered design for something which you've created or a patent. Both of them are quite expensive processes, but you will have no copyright protection, for example, for a nice piece of furniture that you've created. And that's because of this 15.3 capital A provision. And I think that is a provision that needs to be tweaked and to allow, for example, somebody in the township who has now sort of created, like I say, a very attractive chair. At the moment, the Copyright Act will give that person no protection because it's considered to be a utilitarian article, and some big furniture company could just copy that without any concern of copyright infringement. So, for example, there, I think the law could have changed to encourage innovation. The President speaks about the fourth industrial revolution. I can't help but laughing when he says that, and in the same breath, he seeks to dilute intellectual property rights, which are the engine for driving innovation. So, you know, the ANC government clearly is hoodwinking the South African population. They speak a good rhetoric, but when it comes to the brass tacks and you see what they're doing to legislation, how they're diluting intellectual property rights, that's a real concern.
Prof, what constitutes acceptable exceptions for you?
Well-defined exceptions, not this American-type fair use regime which we are now being forced to accept. So, for example, in 97%, 99% of the world, we have a system of fair dealing exceptions, so particular exceptions which are drafted for specific purposes.
So let's explain what that means. What is fair use?
For example, copyright, I'll explain. Copyright gives, like Wiseman also said, gives property rights to the author who's created a work. But there are certain cases where you don't need the author's and copyright owner's permission to do certain things. So, for example, using material for study purposes, right? Or for criticism or review. Now, those are specific exceptions written into the Act. And they've worked wonderfully for the better part of, I don't know how many decades, because people know exactly when it will constitute copyright infringement and when it won't. Now, they want us to adopt an American fair use standard, which doesn't tell you what purposes are acceptable. It actually leaves it open-ended, and it says, well, any use could potentially amount to fair use provided you measure them by these 4 factors. And you know who's going to measure those 4 factors? A judge at the end of a very long and very expensive court process. And guess who that type of system suits? It suits people with deep pockets like Google, who have lobbied for this type of legislative provision, not only in South Africa, in countries like Australia, Hong Kong, because it suits their modus operandi, because they have deep pockets and can litigate you to death. And authors and copyright owners, with that threat which they face, will capitulate and accept any pittance which YouTube or some other Google entity offers them, because that's the only game in town.
Okay, so you, I'm gonna come to you and to say, we have heard what copyright is. We've heard what your criticism of this is. After Wiseman's answer to my question, I want you to start thinking about what next, and to say what would you think would be appropriate going forward. So Wiseman, a mother sitting in Alexander, in an impoverished township, the son is friends with someone that goes to a rich school, and they're able to afford to buy textbooks, they're able to afford to buy fiction books as novels. She takes this book from the friend and goes and copies everything. Goes into a photocopying shop and copies the entire book. Is that acceptable?
So with the new coachings in the bill, that would be.
That would be acceptable.
Yeah.
Yes.
But in the current thing, there's certain types of
but surely
that should be allowed.
No, but surely, if your criticism of the bill accepts the proposition I'm making that an impoverished lady somewhere can take a book and copy it, shouldn't we be applauding that kind of amendment?
No. So there should be certain types of copying that is allowed, that allows academic writers to continue writing so they can earn. Generally, how they earn is that universities pay for the book. And that money is then distributed to the people who actually wrote the non-fiction books via collective management organization known as DALRO. What the bill will do is kill off 70% of DALRO's business.
Isn't there a price for all of us to pay in the search for the constitutional right to education?
The price is not killing education itself, because without an incentive to write academic books, there is no education. You will get what will eventually happen is you will be forced to continue with a very untransformed curricula, because you're going to have to source all your material from international authors. And two, if local writers cannot earn a living from writing the third or fourth chapter of whatever academic book that they've written that is now used by a varsity, it will be outdated.
So in this scenario that I've given, and you say it's acceptable under the new bill, but you register a criticism of it. What should be?
It's not necessarily a full-on criticism, because there's certain things in the current legislation that allows private copying of certain things, right? So if you are, for instance, if I take a CD that I've bought, and I rip it onto my computer, that's an allowable exception, because it's within my private realm. If I take a book that I have and I scan it and I put it in as a soft copy on my phone so I can access it in a different format.
And I copy it and I give it to my friend.
So there's
for academic reasons.
So there is, for instance, you don't need the whole book for you to be able to adequately.
No, I'm doing literature. I'm doing literature, so I need the whole novel. Yeah.
That's where DALRO comes in. And there are all sorts of license agreements that DALRO has entered into with institutions. Mm-hmm. So if, for example, you need your literature, you're studying, whether it's university or at a school, the organization should have entered into what we call a blanket license agreement with DALRO, which will authorize the education institution to make copies of the works that DALRO administers, all the books that DALRO administers, and you pay DALRO royalty. You'll pay DALRO a specific amount every year, whether it's based on copies actually made or alternatively on an agreed fee. Correct. Okay. And that can apply across the board. There's no reason why that shouldn't apply. The danger is with any enterprise, that if there's no incentive for me to create, to make a particular work, to do a particular job, I'm not going to do it. I'm going to do something else. And that goes across the board, whether it's music, whether it's entertainment, whether it's sport, and then whether it's educational material. If I'm not being paid to create that material, I'm not going to do it. I'm going to do something else. I've got a family to look after. And I'm going to, and that for me is a massive risk that our kids are going to face in the future if we're not creating material for education. It's all going to fall apart.
Okay, so where to from here? What would you want?
So I think it's important for the legislature to listen to the representations that have been made by the industries. We've heard from the music industry that they have their concerns with regard to the legislation. We've heard from the academics. The attorneys have voiced their concerns, whether it's independent attorneys or through the Intellectual Property Institute. The book publishing industry has its concerns with regard to the legislation. And I think it's important for the legislature to try and balance the interests of the creators of the works, of the people in the industry, with the impoverished individuals that you're talking about. And I think it is possible to do. I think it's very possible to do with, by way of example, collecting societies that are able to function and function properly, to authorize the copying of the works. But to take away the protection and the monopolies that has been afforded by the copyright legislation, I think is very dangerous, and it can have the unintended consequences that we've seen through other well-intended legislation that just unfortunately hasn't worked. We need to protect our creators, and we need to ensure that the creators get their due compensation, and that we don't have impoverished artists dying just because they haven't received their royalties, their due income. So,
Prof, as we are wrapping up the show, maybe let me put the same question to you. What do you think should happen going forward now that we are here?
Firstly, about textbooks and so forth, that is a red herring like nothing else. So when textbooks don't get delivered in Limpopo, it's not a copyright problem. It's not because copyright is too expensive, etc. It's systemic government failure that there's no textbooks delivered. So, for example, if government has a problem with the cost of textbooks, they can commission an author to write a textbook for the government and print it to their heart's content.
Yeah, so Prof, what I need us to do is to move towards what you think is an appropriate way of finding some form of consensus around, so that we balance the interest of the authors and what is close to my heart, the most impoverished amongst us, and the importance of right to education. And by education, I don't only mean formal academic education. I mean education by getting access to anything written. So what do you think should happen going forward?
So my way forward is I'd like to know how it is that you can still have a bill in the current form given all the opposition. Isn't that signs that this agenda has been captured somewhere? I would like to get that to the bottom of that. How, as you said, as Wiseman said, in the face of vociferous opposition and a piece of legislation that could do untold damage to our economy going forward, how is this still proposed as legislation?
Okay, Wiseman, as we wrap up, what is it that you want us to end on? Yes.
Okay, so I think one of the main things I want to highlight is the bill was particularly from a music industry. The bill was the process was kickstarted by the fact that there were musicians dying paupers.
Yes.
Part of the cries of the music industry was that individual authors do not have enough money to fund the creation of their own music, such that they need to rely on organizations that do have the funds to fund it. And now what the bill has done is taking those very same authors and musicians who can't even on a level fund their own creations, and put the burden of making this new legislation work via the new fair use thing by saying they need to go to court to fund the jurisprudence necessary to make sure that the new amendments work. It is a travesty.
No, thank you very much, gentlemen. It has been a very interesting discussion. I certainly have learnt a lot, and I hope that Mkhaya have equally learnt a lot. And I think it's a conversation that needs to continue to happen as the bill winds its way through the necessary legislative channels. Prof, thank you very much from Cape Town, and I hope to get a passport to come there very, very soon. Wiseman and Hugh, thank you very much for being in studio.
Thanks. Good night, Mkhaya.
Thank you.
Rewinding Kaya FM on FM Rewind. Visit kayafm.co.za for more.